Welcome to the channel. Today we are discussing one of the important concept of evidence. That is a leading question. Our leading question is dealt under section 146 of Bharatiya Sakshya Adhiniyam, and it was dealt under section 141, 142 and 143 of the Evidence Act. Here, first we will understand what is a leading question. Leading question is suppose a person is asking a question and he expects the other person to answer in such a manner. So, in a way, he is prompting the other person to answer in a specific way. So that is a leading question. For example, if I ask anybody, let's say if I ask my friend, have you stopped gambling? This question, the answer to this question, if he says yes, it means that previously he was gambling, now he has stopped it. If he says no, it suggests that he is still continuing gambling. So this type of question does not give the other party the authority to give a correct answer. I am prompting the person to give the answer in a specific way, only in the way which I want. So such type of questions are called leading questions. Leading questions usually will be in a yes or no format answer. The answer will be in a yes or no format for whatever the question is asked. So leading question is permitted in cross-examination. Suppose in cross-examination, the prosecution may ask the accused, were you present at the crime scene? These type of questions are permitted in cross-examination, but in chief examination and re-examination, leading questions are not permitted. Exceptions in these conditions, the leading question can be asked in examination in chief and in re-examination. Those are if it is in the introductory facts of the case. In such cases, leading question can be asked, and it is not disputed by the other counsel, the opposite party, then leading question can be asked. And the third exception is if the court approves the question, then leading question can be asked by the counsel. Let's understand this with the case laws. You will understand it better there. In the case of Bharatiya vs. Emperor, it is held that it is the duty of the court to ensure the validity of leading question. So, determine what question is a leading question. It is left to the court discretion. The parties always feel that it is for the delivery of justice, these type of questions should be asked. Because both parties, it's at the stake that they should win their cases, either for the prosecution or for the defense counsel. But it's for the court to decide how justice should be delivered. So it is left to the court discretion to determine what is the leading question. Another case, Punjab Singh vs. State of Punjab. In this case, it was held that the court should not permit the counsel to ask irrelevant question in order to ensure that the court's time is not, the precious time of the court is not spoiled by the counsels by asking irrelevant question. In the case of Prakash vs. State of Maharashtra, in this case, it held that scandalous question or irrelevant question should not be asked by the counsel. If they are asking, they should justify with reasons that it is necessary for the case. So in this video, we have understood what is the leading question and then what circumstances leading question can be asked. To quickly sum up, leading question can be asked in only cross-examination. In chief examination and the re-examination, it can be asked with the permission of the court, or if the other party does not dispute it, or in the interpretation.